from the state.
Good morning. I'd like to reserve 2 minutes. May it please the Court, my name is Edward Telachia. I am Senior Assistant Attorney General, and I am Chief Counsel to the Florida Board of Medicine. This case, while there's many issues that have been raised involving the constitutionality of Section 766-203 and 458.331-1JJ, it's simply about whether the interpretation of the Florida Board of Medicine, when it ruled on the exceptions in the disciplinary case with Dr. Vazquez, was a non-rule policy. The constitutional issues are currently teed up at the Circuit Court up in here in Leon County, so I would like to go over some of the facts on this case, because I think the facts on these cases really points to the issue of whether this is a non-rule policy or not. This case, of course, began in a medical malpractice.
Why do we need to look beyond the face of the statute in order to determine that this sort of bizarre procedural twist is a non-rule policy?
Why do we need to look, I'm sorry,
Why do we need to look beyond the face of the statute in order to determine that your construction of the statute is a non-rule policy?
Well, because we need to determine whether this construction of the statute was of general, well, whether the board's interpretation was of general applicability. In other words, was it restricted to this particular case?
The board essentially took a position, correct me if I'm wrong, that unless DOA or somebody allows the physician an opportunity after the fact to put on some proof, then the statute is unconstitutional.
Well, the Board of Medicine took the position that Dr. Vazquez did not receive the opportunity, did not get the opportunity.
Did not receive due process.
Correct. Did not get the opportunity to defend himself on the circuit court level.
And you're saying that's not generally applicable once the board has taken that position, that a constitution, that a statute, absent this after-the-fact opportunity for due process is not constitutional. That's not a general. In the next case, you're going to say the statute's just fine?
Well, it depends on what happens in the particular case.
But, I think the judge's comments, excuse me, are you could have a circuit judge today in Leon County report a doctor for giving an unfounded opinion that another doctor's committed malpractice. By law, that circuit judge is required to report that finding to you, right?
That is correct, yes.
And by law, and perhaps to the agency's great credit, you determine that, well, wait a minute, a doctor in that case doesn't receive due process. Well, and we're going to have to allow that doctor to obtain an evidentiary hearing, right?
Well, in this particular case.
Understand, just divorce yourself if you can for a moment from this case. In the hypothetical, if that happens today, your view, I'm sure, is you have to allow the doctor due process.
At DOA, if we're talking about it. Yeah, and that is correct. And
you're going to do that every time a circuit judge reports a doctor to you, which under this statute, you have to say that's a disciplinary action. But you know, apparently, that the best course of action is to allow those doctors in the future to challenge that finding.
Well, if they do not receive due process on the circuit court level, and I think that's the key here. In the future, we don't know how these cases.
Counsel, wait. I don't know if you've ever done any civil litigation before.
No, I haven't. I'm administrative law attorney.
You're the plaintiff in a medical malpractice case. You've got this doctor's opinion. Say it's Dr. Vazquez, and he says, every physician within 100 miles of me was negligent and signs his name to it. And you go into this hearing on the hospital or the doc's motion to dismiss. If I'm the plaintiff in that case, that doctor is not going to be heard in that hearing because he doesn't have any right to be heard in that hearing. Would you agree with that proposition? That doctor does not have a right to come in affect my substantive rights by testifying that his opinion was good. That's up to the defendant. Well,
that's correct. I mean, the physician, the expert who gave the corroborating expert testimony is not a party in the case.
What I'm suggesting is that due process hearing is never going to take place under the terms of the statute, and I think that's what Judge Thomas is suggesting also.
Okay. Well, if that is the case, though this is the case of first impression.
Why don't you just concede that this statute is unconstitutional and get it amended?
Well, unfortunately, getting these statutes amended, I'm sure you realize, are more difficult than.
But it is unconstitutional. Well, you all took this position before the agency when you asked for remand back to DOA.
Well, we took the position that as it was applied to Dr. Vazquez, it was unconstitutional in that he was denied due process.
Have you conceded that it's unconstitutional? Has the Attorney General's office conceded the statute's unconstitutional in the Leon County Circuit Court?
No, it has not. That case is currently, basically, it's currently waiting for the outcome of the administrative action before they go forward with it.
So your argument is your construction makes it constitutional? Your construction of the statute, that there's an entitlement to some kind of hearing, makes the statute constitutional?
Whether it makes it 766 constitutional?
458.
I'm sorry, 458. Yes, well, that's what we're trying to do here.
Yeah.
We're trying to give him what he is asking for, and that is the due process.
Yes.
So,
and,
yes.
And the agency's probably entitled to assume that that the legislature, in passing this statute that has pretty much conclusive effect, was aware that there has to be some kind of notice and hearing and due process allowed somewhere along the line, right?
That's correct.
You're
yes.
trying to do that.
And that's what we're trying to do under these circumstances. Now,
But of course, the doctor in this case has made a pretty vigorous argument that even if somehow this construction that the ALJ found was contrary to any reasonable reading of the statute could stand, your construction can't stand constitutional scrutiny either, because it establishes a prima facie case that the doctor's committed a disciplinary violation.
Well, I guess you're kind of, that's correct, yes.
So any other doctor who's reported by a circuit judge is going to have the exact same argument, and no doubt will have the exact same argument, and you're going to have to argue again, well, we want you to have due process. I mean, as commendable as that may be under the circumstances, we want you to have due process. Therefore, we're going to ask the division to grant an evidentiary hearing. While commendable, that's going to be generally applicable, isn't it?
Well, at this point in time, we don't know if it's generally applicable.
I'm asking you a hypothetical.
If it happens in the future, yes, it would be generally applicable. And
if it happens in the future, you're going to do exactly the same thing.
Well, but at that point in time, we would enter into rulemaking. If we determine that this is going to happen on a regular basis and this is going to happen all the time, then yes, at that point in time, you have to...
The statute doesn't give you the right to make a rule for a due process hearing after the fact, does it?
Well, for a due process, well, no, not after the fact. I think if that case comes forward, we're going to have to go into rulemaking as to how we're going to proceed with that case.
Good luck
But under
with
the
that.
APA,
Yeah.
Well,
Do you have specific
I think
rulemaking
Judge
authority for
Cohn's
that?
Well, that's not an issue that I've really gone into as to whether we have specific rulemaking authority, and I'm not really prepared to discuss that, but I would look into it, of course. And if the board does have rulemaking authority, they will go into rulemaking authority. They will go into rulemaking.
Your argument here is essentially, and in your brief, that this may be just an incredibly unusual situation. It's unlikely to ever happen again. Therefore, our attempt to make this process work under the statute is not generally applicable.
That's correct. But we're not arguing that it's not likely to ever happen again. It may happen again.
Well, the legislature thought it was a problem. They passed the statute specifically on this.
Right. This is the first time this case, the Board of Medicine, has ever seen a case under this provision of 458.3311JJ.
Maybe you should have waited a little longer rather than prosecuting this case.
Well, that may be the case. But the cases come to the Board of Medicine, and they deal with them as they come before them.
You've done a good job of being steadfast in the face of a barrage of questions. We appreciate that professionalism. But let's look at the face of 458.333.1 sub double J. Would you agree that on the face of that statute, forget Dr. Vazquez, forget the medical malpractice claims in Pinellas County, would you agree that on its face, thinking back to cases like Kahn versus or Chevin, that this statute on its face, if it's applied strictly, denies the physician due process? I understand it's difficult for you because you've got a case pending across the street.
Right.
How do you read this statute otherwise?
Well, it's a difficult interpretation, I agree, but the Board of Medicine was forced to provide this interpretation in order to provide the due process.
We understand the Attorney General has an obligation to defend the constitutionality of the state laws, and we certainly understand the difficult position you're in today. However, there is a motion for attorney's fees in this case. and I'm not sure the Attorney General's office is obligated to prosecute an appeal. Would you address the motion for attorney's fees if you can?
Well, I mean, this is a non-rule policy challenge, and with non-rule policies, the statute is very clear that if you do not prevail in a non-rule policy case,
they're entitled to fees anyway.
Yeah, they're entitled to fees and costs anyway. You know, again,
so we don't need to get to the good faith type argument.
But didn't ALJ Sarton reserve ruling on the motion for attorney's fees at DOA?
Well, that's correct, but
Pending the appeal.
Pending the appeal, but on a non-rule
So your
policy.
presumption is whoever wins this, let's say hypothetically that the doctor wins the appeal, the agency's presumption is that there will be attorney's fees due and there won't be any, we won't have.
Well, that's correct, because it is a non-rule policy challenge, and 120 is very clear on that, on non-rule policies. There's going to be attorney's fees and costs if Dr. Vazquez prevails on the particular case. But again, as I was saying earlier, this is a very unusual case. It's the first time it's been presented to the Board of Medicine, and just in and of itself, being that this is the first time that there was an interpretation of it, and given the unusual circumstances, it'd be the Board of Medicine taking the position that it's not of general applicability. This is going to be, in the future, of course, if it comes up again, and it is what Judge Kahn mentioned earlier, that we are going to be encountered with a situation where there is no due process provided to the expert at the circuit court level, then in that particular case, again, we will have to make a decision as to how to proceed with that case. But at this point in time, we believe it's premature to make the determination that this was of general applicability. It was applied to this particular case. And if you look at the facts, and I won't go through the facts now because they are somewhat extensive, if you look at the facts in this particular case, it's quite, it's somewhat unbelievable that the ALJ, Sarton in this case, determined that this interpretation of the statute was not based on the facts of this particular case. Now, I'm saying based on all the procedural facts that were surrounding this particular. The only reason the Board of Medicine made this determination in this case, made this interpretation in this case, is because of the lack of due process that Dr. Vazquez did not get, of course, in the circuit court level. And with that, I will just go ahead and reserve the rest for rebuttal if necessary. Thank you, Your Honor.
I designed my folder for the 3rd District's podium, but yours is a bit small. I think the important thing to remember here is this interpretation, even if you accept it, is not constitutional. The judge in the circuit court action heard no evidence, gave no notice. There was not even the plaintiff's lawyer there, and they want to make his comment, and I got to read it to you because it's unbelievable. Quote, apparently without investigating. He didn't even make a finding. We took this to the 2nd District on a 1.540, and they wouldn't hear it because we don't even think this was a finding. We lost that. Okay, this is a finding. What is the finding based upon? It's based upon the fact that he wasn't there, and it looked to the judge without opposing argument like it wasn't enough, apparently. They want that to be prima facie evidence of clear and convincing, to satisfy clear and convincing evidence standard. He did something wrong. That interpretation is a violation of due process. And so the argument here that they're trying to help us by providing this opportunity is just not true. And I agree with Your Honor. I've been arguing this since we filed that Leon County Circuit case. They went forward with the hearing in this case, and they went to the final hearing based upon the arguments that all I had to do was put the order in evidence, and they won the case. When I filed the statute,
they almost have to take that position because otherwise they would be conceding that the statute is facially unconstitutional.
Well, when I filed the Leon County action saying it was facially unconstitutional, the Attorney General got involved. That's when the new interpretation came in. After the hearing, the point is, I think, although they're not conceding it's unconstitutional, everything they did in this case was a recognition of that fact. What I'm trying to say is even the attempt to fix it is itself unconstitutional. And if you could please write an opinion that says that, we're going to be here for 5 more years. This is the 4th proceeding in this case. They want to have him stand here with his license revoked making this argument.
Well, certainly you being an experienced practitioner you are and knowing the APA, appreciate the difficulty that a very competent agency lawyer finds himself or herself in.
I don't.
We have said, and I know I have said many times, Judge Thomas articulated today, that the state has to defend its statutes.
I appreciate
don't like
that.
the idea of.
I appreciate that, but I think now that we're in our fourth proceeding, we don't want to come here and stand in this podium with a revoked doctor who can then argue it's unconstitutional as applied. I think everybody knows it's unconstitutional applied. If you would write that in an opinion, and I can go to the Leon County Circuit Judge and show him the opinion, we can end this
It
case.
would be dicta. Even
It
our
would help.
dicta- even
I
our
don't know if we
dicta
can
is-
rule that in this case.
Whatever you can do. I could go into more detail. I think the focus here should be on the order below. The order below was very detailed. It was based upon a stipulation of facts. The parties were able to agree what had happened. I think that the ALJ found that the rule, quote, establishes a procedure or method of proof unrelated to and unaffected by the specific facts involved. That's in my answer brief at 9, and the ALJ's findings are 217 and 118. It really has nothing to do with the facts of this case. Every single case will require a full hearing, and the full hearing should be without prejudging it based upon a presumption. The other issue is if this case does go into rulemaking, as we're trying to force it in, this is not a proper presumption. Only the legislature has the power to provide presumptions, and this will be defeated in rulemaking if it is indeed put in that posture.
You know, everybody in civilized society knows you can't take away a doctor's license without having some kind of hearing and adjudication. What is wrong with the agency coming to the conclusion that certainly the legislature knew that and anticipated that there would be an evidentiary hearing before the Board of Medicine?
Well, that is not what they said. They said, quote, being found by a circuit court judge is the offense. They didn't say doing it is the problem. Being found. That is the language of the statute. That language is unconstitutional facially. And a facially unconstitutional statute cannot be saved by a construction that is itself a violation of due process.
But your argument is even if the agency's response and attempt to grant due process, even if totally proper, it's a rule of general applicability.
In this
You
case,
win either way.
in this case, I agree. I'm just asking a little extra because I don't want a fifth case. I don't want to keep going on this. You know, the doctors pay a lot of money. It's been a very difficult time. I really want to end it here if we can, and I think that your response is the response I had in the beginning, and if we could get that on some paper, maybe we could get it closed. I have any more questions, and I'll answer them. I think I've covered my points. Thanks very much.
Just real quick, with all due respect, Mr. Mayor, in this court, I don't believe you folks can go ahead and rule on the constitutional issues here today. This case, again, it's solely on the non-rule policy issue. And again, keep in mind that the Board of Medicine, all they were trying to do was give him what he initially asked for.
But that's legally irrelevant, right?
Well, that's correct, but the board's...
As I've mentioned in several of my questions, while certainly commendable and obviously we recognize the effort or the motivation, if it's a policy of general applicability, it's rulemaking.
Well, that is correct. If it's a policy of general applicability and under the limited circumstances of these cases, we believe that it's not.
But if a doctor is reported to you tomorrow, you're going to do exactly the same thing you did for Dr. Vazquez, right?
Under these, if it's under these circumstances, yes, we would have to do the same
Doctor is
thing.
reported tomorrow under this statute, you're going to do exactly the same thing you did for Dr. Vazquez.
Again, yes,
Correct?
under these, if it's the same circumstances that Dr. Vazquez
I
had.
think also, again, with due respect, we do understand the position that you good agency lawyers are in. Most of the time, we appreciate it.
I understand, yeah.
But this is not about Dr. Vazquez. He may have been just as wrong can be. We'll never know, I'm afraid. Or he may have been as right can be. But the problem is, and I think even you would concede, that if he has, this is like the old post-deprivation hearings and the old classical procedural due process cases. If he has to come in before DOA, before the agency and defend a licensing, a delicensing, or whatever you want to get from him for all these months and perhaps years before he even has his due process hearing, it's a fairly significant injury.
I concur. It is. And with that said, thank you very much for the opportunity.
That concludes our docket.